clicked on, which gave me, as of 15 minutes ago, I was staring at myself on the screen. Why it's not working now is anybody's guess.
Okay.
We're recording.
Okay, so good afternoon and welcome to the appellate court. I am Judge Cradle and I'm sitting today with Judge Suarez and Judge Baer. This is the matter of BELLERIVE versus the GROTTO and Liberty Mutual Insurance Company, AC 44138. This is a virtual argument that is being conducted on the Microsoft Teams platform. It is being live streamed on the Judicial Branch's YouTube channel, and the recording of this argument will be posted on the branch's website. To the extent that there is any protected information involved in this case, it should not be disclosed during oral argument. To make sure we can hear and see one another, with the caveat that I understand, although we can hear, we cannot see Attorney Powderly. I will ask everyone to introduce themselves, beginning with the judges and followed by counsel for the appellant, then counsel for the appellee. I am Judge Cradle.
I am Judge Suarez.
Judge Baer.
Attorney Jim Brennan.
Attorney Chris Powderly for the appellee Liberty Mutual Insurance Company.
Okay, and I am able to hear and see everyone with the exception of seeing Attorney Powderly. And if during the course of the argument you do lose a video connection or you cannot hear, please let us know. I am going to ask that everyone mute their microphones when you're not speaking, and that's just to prevent any sort of feedback. Also, please keep your camera on at all times during the argument, just so that we know that you're still present. If the judges have a question, we will raise our hands. And if you don't notice us doing that, then we will just interrupt. Everyone should be mindful that this is, in fact, a court proceeding, and everyone should conduct themselves as if they were present in the courtroom. Each side will be permitted 20 minutes of argument. The appellant may reserve a portion of that time for rebuttal. Please let me know before you proceed, Attorney Brennan, how much rebuttal time you would like. I will keep track of the time. I will let you know when there's 2 minutes remaining, 1 minute remaining, and also when your time is up. Each of you have received instruction prior to today's arguments. If there are no questions, then we may proceed. All right, so hearing none, Attorney Brennan, you may proceed.
Good afternoon, Your Honor. May it please the court, my name is Attorney Jim Brennan. I represent the respondent employer, the GROTTO, and this is a appeal of the Compensation Review Board decision. And a brief history of the case, the claimant, respondent employer, the GROTTO, is a small Italian restaurant in Waterbury, and the claimant, LAUREL, BELLERIVE, suffered a traumatic amputation of 3 of her fingers while cleaning a machine on March 1st, 2016, and she had and the claim has not been contested and was accepted as a claim and found to be a compensable claim.
And Attorney Brennan, before you go further into your argument, how much time would you like for rebuttal, sir?
Oh, I'm sorry, Your Honor, I should have said that. 5 minutes, please.
Thank you.
Okay. After a hearing on this matter, all parties entered into a stipulation of facts, which the trial commissioner, the finder of fact, accepted, and there was also additional testimony from the principal, the owner of the GROTTO, and the commissioner then found, relying on 2 cases, Stickney versus Sunrise, it was a Supreme Court case, and the Bell versus Holt, which is a Compensation Review Board case, and found that the behavior, but based on the facts, which were not contested, the conduct of the insurer, Liberty Mutual, was unreliable, unreasonable, misleading, and inconsistent at best. And then found that the compensation, the insurance policy was in effect on March 1st, 2016. We've also found that the insurance company, Liberty, sent a cancellation notice to the chairman's office pursuant to 31-348, and which requires that after that notice is received by the chairman's office, the policy will remain in effect for 15 days, in which then it can be canceled. So the cancellation would have taken effect on November 3rd, 2015. On November 4th, 2015, one day after the cancellation, the commissioner found that it was not contested, that Liberty sent the Grotto a letter stating that if you don't comply with the audit materials, your policy may be canceled. And and 5 times between November 4th and February 16th, the Liberty sent letters to the Grotto stating your policy may be canceled. They also sent 2 letters, I believe, that said your policy had been canceled. Please send the audit letters. And additionally, the Liberty filed an endorsement, an insurance endorsement making a small change, but stating other than this change, the policy remains in effect. And thirdly, in the commissioner's finding was the Grotto had paid the full premium, and Liberty never returned any of the premium until 35 days after the claimant's injury. So based on those findings, the commissioner, commissioner, was the finder of fact, found that the policy was in effect. So the issue on this appeal and the issue before the CRB was the jurisdiction of the trial commissioner to go beyond the 4 corners of the Workers' Compensation Act in determining whether a policy was in effect on the day of the injury. And more specifically, can the Workers' Compensation Commissioner apply principles of common law beyond the Workers' Compensation Act in deciding the case and whether the policy was in effect? And the commissioner found that he had the authority to do so and did so. This case then went up on appeal by Liberty, brought the appeal to the CRB, Compensation Review Board, which, like this court, sat as an appellate tribunal, and as any court sitting as an appellate tribunal has to respect the findings of the commissioner, the findings of the commissioner and all inferences reasonably drawn from them and conclusions, unless the incorrect application of law applies or the inferences are illegally drawn from them. The Liberty position at the trial level and before the CRB was that the commissioner could not go any farther than the cancellation files in the chairman of the Workers' Compensation Commission's office, which are filed pursuant to 31-348 of the Connecticut General Statutes. The commissioner disagreed and said he thought, based on 2 cases, Bell and Stickney, that he had the authority, and he did so. Now, the CRB took the position that, well, the commissioner can go beyond the strict what is in the files pursuant to 31-348, but the CRB limited that finding to the 15 days between the letters, the cancellation notices received by the chairman's office, and 15 days later when the cancellation went into effect. And he also found that only a rescission by the only conduct to be looked at for by the insurance company is whether or not the insurance company is going to rescind on its own choice the cancellation notice, and the claimant would have the burden of showing it by unequivocal conduct, which introduces a new standard to workers' compensation law, is because compensation burden of proof is always by a preponderance of the evidence. Notwithstanding the fact that the commissioner based his entire opinion on Stickney and Bell, the CRB never even cited, let alone address, why Bell was not controlling. And it relied on Stickney for the position that if you want to contest whether the insurance company's conduct justified finding that the policy was in effect, that would belong in the Superior Court. In Stickney, the case did belong in the Superior Court, and the Supreme Court was very clear in saying that's because Stickney involved a dispute between two insurance companies, Travelers and Commercial Union, and had whatever the decision was in there was no effect on the claimant. In fact, the claimant had been paid in Stickney 5 years earlier. Travelers, in some sort of an audit, realized that the other carrier, Commercial Union, should have paid, and therefore went before the commission and asked that the commission order Commercial Union to reimburse it. The Supreme Court says, following a long precedent, that insurers cannot go beyond the 348 files, those files in the commission chairman's office, but employers can. And in the case, oh, yes, Your Honor.
So if NCCI lists a policy as being canceled, your claim is that then it's not effectively canceled?
My claim is that the conduct of the insurance company after the alleged cancellation can be used to determine whether or not the policy was in effect on the day of the claimant's injury, provided the claimant's benefits are at stake in the case.
Okay.
And that has been, in the Bell case, that was distinctly what happened. There was a cancellation notice filed. Afterwards, the employer continued to make payments, and the payments were accepted. And the commissioner found, the CRB affirmed that the cancellation notice was not valid because the employer was lulled into believing that the policy was still in place. And also DeBello, which was affirmed by this court, it was a case where there was no insurance policy ever in place at all at the time. But what happened was the employer had sent $56,000 to the insurer's agent. The insurance agents converted the money to himself and never paid for the policy, and then sent the employer a letter on the insurance company was letterhead stating that your policy was in place. And therefore, the court said, the CRB, and this court approved later, that the commissioner had the right to look at the insurance company's agent's conduct in determining whether or not the policy was in place.
But but the Grotto received several letters from Liberty Mutual, though, that also indicated that, or suggested that the policy was canceled.
I believe it was 2 letters, Your Honor.
Okay, 2 letters, and
Yes.
that would have been effective back in November, I believe, of 2015.
Correct. But that's what the letters would have said. That's when the cancellation would have went into place. I mean, by the 15-day period after it was filed with the chairman.
Right, and in addition to that, the Liberty Mutual was requesting that that the Grotto send information to it so it can conduct a proper audit, which the Grotto did not do in a timely manner.
That is correct, Your Honor. But it says your policy, but 5 letters said your policy may be canceled if you don't send this audit material for a former policy, not even the subject matter policy. And it also said, it sent an endorsement, which is, endorsements are clearly, the policy remains in effect except for one minor change, which really didn't affect, anything on this issue. And like I say, there's all the case, the Bell case and the DeBello case, and then in the Jordan case, which was a long time ago, which I cite it in my appellate's brief, and I also put it in my appendix because for some reason, I don't know why, it wasn't on Westlaw. So I was able to get a copy from the chairman's office, so I put it into the appendix. And that was the Vernon case a long time ago. Again, the board said the commissioner can look beyond the dates if the conduct is misleading and is misleading and applying the CRB relied on the Ulen case, which was a case from this court that was really not pertinent to the issue, because the Ulen court only dealt with one issue: who must be notified for a cancellation pursuant to 31-348, and that is the chairman of the commission, not the employer. So the CRB in this case said, well, then the knowledge of the employer is irrelevant, but that wouldn't be the case. Again, and it's Stickney, and we went back to Stickney. And in Stickney, if you look at footnotes 5 and 6, which is what the commissioner relied on, in Stickney it said whether or not the commissioner can apply concepts of common law we'll wait for another day. But and in DeBello, the CRB said that another day has arrived and found that they can apply the common law principles. So therefore, those two, well, Ulen didn't apply except for the notice, and the commission definitely apply. In Stickney didn't apply as far because there's two insurance companies, but the court did say that commissioners often have to go beyond the act and apply other acts or constitutional provisions in deciding cases. So, in matter of fact, Liberty Mutual even gave up its the argument didn't sort of seem not to agree with the CRB because it did address footnotes 5 and 6 in Stickney and the Bell case and other cases. And finally, my one last point was I said the notice issue 31-321 requires that notice be certified unless other by rules of the court. 31-348, the legislature strictly mandated that the Workers' Compensation Commission develop rules. When I did a motion for articulation, they never adopted a rule. So therefore 321 would apply, 31-321 would apply. And since it's a legislative act, it's created, lives and dies by the legislative fiat. And I close my argument that the notice was not good. Thank you.
Okay, Attorney Powderly.
Good afternoon, members of the appellate court. As you can tell from Attorney Brennan's argument, this is certainly an out of the ordinary case, absolutely out of the ordinary for workers' compensation, where usually you're talking about did an incident arise in the course of and out of the employment, or is somebody a statutory employee? This is really, with it being a contractual coverage issue, it's certainly out of the ordinary for workers' compensation. Now, the first thing to deal with, which Attorney Brennan dealt with last, is he has raised an argument that under 31-321, that most communication and most forms filed with the commission have to be either registered, certified, or personal service. Now, and it's agreed to that the notice to the NCCI, which canceled the policy, was not mailed to the commission registered, certified, or personal delivery. It was sent to the NCCI electronically. And I almost thought that argument was going to be waived, but in any event, the trial commissioner found that 31-321 applies to insurance cancellations that, in addition to it being filed electronically with the NCCI, somehow it also has to be mailed to the commissioner's office, either registered, certified, or somebody has to show up in person and deliver it. No authority was cited by the trial commissioner for that proposition, but basically the cases that control this actually are two appellate court cases. The first case being the Dengler case, and the second one being the Yelenin case. In any event, the Dengler case basically points out that in that case, the notice that they were talking about was sent to the NCCI, and it's listed in the facts of the cases having been sent to the NCCI. Nowhere in the Dengler case, which is 62 Conap 440, 2001 case, nowhere in the Dengler case is it even remotely indicated that in addition to electronic notification being sent to the NCCI, that notice was, because notice was found to be sufficient in that case. Nowhere does it indicate that that notice was also additionally sent, registered, or certified. That's simply not in the case. And to the extent that Attorney Brennan is relying on the Dengler case for the proposition that basically two notices have to be sent to the chairman's office, one through the NCCI and one put in an envelope, and you go to the post office and send a registered letter, that case just doesn't stand for that proposition at all. And also, again, the Dengler case also points out that the NCCI is the agent for the Workers' Compensation Commission. That's also brought out in the Yelenin case, which is also a CONAP case, CONAP 144, a 2010 case. In that case, it's also discussed that the notice which was up on appeal in that case which was found to be valid, was only sent to the NCCI. There's nothing in that case to indicate that it was sent to the commission, registered, certified, or personal delivery. It probably wasn't. And notice to the NCCI was found to be valid. The Yelenin court also points out, as I indicate in my brief on page 11, that the NCCI is, quote, the designated agent for the chairman's office for receipt of compensation insurance policy cancellation notices. Also, as I indicate on page 11, that if you actually go to the workers' compensation website, right on the website, it indicates that the NCCI is the registered agent for service for the commission, and that all information sent to the NCCI as far as cancellations go is actually listed on their website, that you can actually go in and see if policies have been canceled or not. Lastly, after the trial commissioner found that, without stating how or why or any authority for that proposition, that 321 applied and you still had to send it registered, certified, or personal delivery, when it was appealed, the CRB specifically said, because one of the bases for my appeal was that 321 also says, it says registered, certified, or personal delivery. It says, or by other methods as set out by the commission and depending on the facts of the case. When the CRB reversed the trial commissioner on the 31321 issue and said that it did not have to be sent registered, certified, or personal delivery, and electronic notice to the NCCI was enough, Attorney Brennan filed a motion for articulation, as he said he did, and the CRB panel filed a lengthy ruling on the motion for articulation. And this starts at page 12 of my brief and lays out the whole process starting in 1989, whereby the Workers' Compensation Commission, in conjunction with the State Senate and the State House of Representatives and the Attorney General's office, attempted or took steps to put in place a new system where simply for cancellation notices and for initiation and cancellation of policies, that the NCCI was going to be the agent for the state. And it says that it would be handled by electronic notice to the NCCI rather than in writing to the commission. This is in the appendix. Let's see where it is. I have it as in my appendix from pages 80 to 85 But in any event, when Attorney Brennan said, where's the authority that you only need electronically notify the NCCI? Where does this come from? The CRB, who I think ought to know what their own rules are, sent out a 5-page ruling on the motion for articulation, laying out the legislative history by which 31348 was amended to include notice to the NCCI and to take it into the electronic age. And also just generally, I mean, given the black letter law that statutes are supposed to be construed as to make some type of common sense, it just simply doesn't make sense that in addition to setting up an electronic notification system that the public can go in through the comp website and check what policies in place and what aren't, given that this electronic setup has been set up, why there ever would be a need for also sending a registered or certified letter, it just kind of strains credulity. But in any event, I don't think credulity factors that much into it, because the CRB laid out an answer to Attorney Brennan's question, the answer to why do you only need to electronically notify the NCCI. They answer the question with their memorandum. And so basically, that's one of the two issues, was the policy validly canceled pursuant to 31321 and 348. Trial commissioner said no. The CRB, as a matter of law, doing de novo review on statutory construction, said yes, the notice was sufficient and the policy was validly canceled. So I think that takes care of issue number one. The second issue is, with the understanding that the policy was validly canceled, did anything subsequent to the valid cancellation somehow undo the valid cancellation? And that's what gets us into the jurisdictional issue and the common law Stickney issue. I have to say that I disagree. Just as an overview, I disagree with Attorney Brennan that Stickney and Bell and DeBello are authority for the commissioner finding that those subsequent correspondences, which again, those are agreed to facts, that after the policy was validly canceled, in an attempt to get the audit information that they had been looking for a very long time, Liberty sends out 7 or 8 correspondences to the employer. 5 of them say, send the audit material or we may cancel your policy. 2 or 3 of them say your policy is canceled and we still need the information to compute what the actual premium is, because only a approximate premium was paid up front. But Attorney Brennan is citing Stickney and Bell and DeBello for the proposition that basically saying that those cases are dispositive, that the factual allegations in BELLERIVE support a finding of support a finding that the valid cancellation was undone. And that's just not really an accurate reading of the cases. First of all, Stickney, in which the Supreme Court upheld the appellate court, didn't say that any and all common law theories and any and all evidence can come into play as far as whether or not a cancellation was valid. It said that under proper circumstances, common law information and theories can be looked at. It didn't say it has to be looked at, and it didn't even say it's dispositive. It just said it can be looked at given the proper situation. Bell and DeBello also didn't decide anything. Bell and DeBello were not. Let's go with Bell. Bell is a case where the carrier said there was a valid cancellation. The claimant came forward and said, claimant and the employer came forward and said, wait a second, your argument is that there's a cancellation because we didn't pay the premium. We are going to show evidence that we did pay the premium. Now, that would absolutely be the unequivocal evidence that the CRB referred to when they used that term. The CRB didn't say that that's dispositive and it set aside the finding of no coverage. All the CRB said was the commissioner was wrong to think that he or she could not look at that information, because that's what the Bell trial commissioner said. Trial commissioner said, listen, I'm sorry, but I can't look at this. I can't go beyond the NCCI. They issued a dismissal. It goes to the CRB. The CRB said, no, you can look at that and it's relevant and we're sending it back to you to look at that. So how Bell actually turned out, nobody knows. And whether or not that was evidence that swayed the commission, the trial commissioner, nobody knows, because the only thing that Bell stands for is that a commissioner can look at that type of evidence and send it back. The same thing with DeBello. In DeBello, the respondent said that I've got a valid cancellation. The employer said, wait a second, the basis for your cancellation, the basis for your denying coverage is you said there's no policy. We have unequivocal evidence that a broker, the agent acting on your behalf, took money and also gave us a certificate of insurance. And the DeBello CRB panel relied also on, aside from agency law, relied on the fact that the Workers' Compensation Commission recognizes in a very special way any circumstance where a certificate of insurance is issued to an employer and that the employer has the right to rely on that. But all the DeBello panel did was send it back to the CRB and say, send it back to the trial commissioner and say, you were wrong to think that you couldn't look at this. You can look at this. It's within your jurisdiction. Now, what happened, again, is anybody's guess. We don't have any subsequent DeBello decision where the trial commissioner said, okay, I am now convinced and there is coverage. All DeBello stands for is that type of evidence is within the jurisdiction of the commissioner to look at. The only evidence in this case that would be even remotely analogous to the evidence that the CRB said was relevant in Bell and DeBello would be if the Grotto came forward and said, hey, you're saying you canceled my policy because I didn't send in the audit material. I did send in the audit material and here it is. That's not what happened here. And actually it's in the appendix and argued in the brief, but when the principal of the Grotto was deposed, I asked her, is it true that you didn't send in the requested audit material until after March 1st, 2016, after the claimant had gotten hurt? And she said, yes, that's true. That's when I sent it in. So there's no evidence, there couldn't be any evidence in this case that there was any evidence analogous to the evidence that the CRB validated and said was relevant in Bell and DeBello. Also, here's another, this is, again, it's an odd case. Also, I would like to just kind of as an aside say one thing, which is that in addition to, and this is not necessarily evidence, but I put it in my counter statement of the facts, I would like you to please note who is not here today. And we have Attorney Brennan for the employer, but who we do not have here today is the Second Injury Fund. When the CRB found that there was no coverage and set aside the trial commissioner's decision as to coverage, the party that became responsible for paying benefits to the claimant on behalf of the now uninsured employer, the Grotto, was the Second Injury Fund. They now are, not to use a kind of a colloquial expression, they're now on the hook for benefits. They have taken my place and they now have to pay the claimant benefits. They did not appeal the CRB decision, which put the liability onto them. They didn't, but the Grotto did. But in any event, one of the problems with this common law theory argument is that the commissioner didn't find or apply any common law theory. The Grotto's argument is that the trial commissioner had the right to find and apply a common law theory. And the theories that had been mentioned in the brief of the Grotto are negligent misrepresentation, waiver, and estoppel, and that the claimant, that the trial commissioner had the jurisdiction under the Compact to find those. The problem with that whole argument is that he didn't find those. There is nothing in the finding, the May 24th, 2019 finding by the trial commissioner that says that, which was really one of the problems to begin with. Kind of in a, pardon me a second, I'm just going to go to the finding and the CRB argument. The CRB argument and kind of the CRB decision, pardon me, and kind of showing their good manners kind of says, well, we're not really sure why the commissioner found what he did because he really didn't say so, but we'll assume that he was relying on these facts. The trial commissioner, the dispositive facts found by the trial commissioner on which he found that the NCCI valid cancellation was somehow undone said that, one, that the letters to the employer were inconsistent at best, was his terminology. And secondly, he found that, thank you. Secondly, he found that in addition to the letters being inconsistent, he found that the Grotto had a belief that they had coverage. Well, the Yelenin case and the Dengler case both stand for the proposition that once a cancellation is valid, it is legally irrelevant what the employer thinks. It's just not a relative discussion that for some reason, even though there was a valid cancellation, the employer thought they still had coverage. So that really was a non-argument. But that somehow the fact that there was inconsistent correspondence, which I actually can agree to that somehow undid the valid cancellation. There were no facts that would support misrepresentation because what the employer thought was irrelevant. There was nothing in the record that would support a waiver, an intentional relinquishment of a known right. There was nothing that would support an estoppel, which is any action by the carrier which was induced, that was done for the purpose of inducing reliance, and then there was reliance. There was no indication there was reliance. There was no indication that the inconsistent letters were the purpose of them were to induce reliance. There just was no there when it came to the trial commissioner saying, here's how these facts plug into a theory, which adds up to invalidation of the prior valid cancellation. He just didn't even go remotely near that. He just said, it does. And when I filed a motion to correct and asked the trial commissioner to would you please lay out how these unrelated facts somehow add up to, my motion to correct was denied. Thank you for your time.
All right, thank you, Attorney Brennan. You do have 5 minutes. And Attorney Powderly, if I could just remind you to please mute your microphone.
Yes, thank you.
Thank you, Your Honor. Your Honor, in argument, Liberty's counsel argues that the facts don't establish that there could be a misleading tort of common law. But the commissioner's findings, the fact finder, what he found stands and all conclusion stands unless it's not, he misapplied the law. And in Stickney did not decide that common law was accepted. It said, we're going to wait for another day. It was DeBello, which this court then affirmed, which found that common law principles, as well as statutory principles, regulatory principles, or constitutional principles, can be used to determine whether there was an insurance policy in place if the claimant's benefits are at stake. So the CRB, sitting as a tribunal an appellate tribunal basically had to accept its facts, but it didn't. It's saying that, and it limited, it said can't apply common law, even though 5 other decisions from the CRB said that they can go, the cases were sent back for the commissioner to do the findings. And that's exactly what the commissioner did here. He made findings, and the CRB said, well, we're going to limit those findings to did they unequivocally rescind it within the 15 days, and they're not going to look any other future conduct. So therefore, basically, they sub saliento reversed their own opinion, their own precedent. And the tribunal, the appellate tribunals have to, if you're going to change stare decisis and overrule it, you should certainly, the CRB certainly should have said why those 5 cases, Bell, DeBello, Lee, Bruce, and Vernon did not apply, and they did not apply. And they did not address that at all. I would just go to the 321 argument. Again, the statute seeks for itself in 31-348, which controls how notices to be filed. It says, it prescribed that the commission prescribed rules. They in their CRB decision, it said based on the rules of the commission. I then did a motion for articulation and said, what rules? I couldn't find any rules. It gave a long brief and a memorandum, but never adopted rules. So therefore, the Workers' Compensation Commission didn't even follow the legislative mandate to adopt rules. They did conduct. This is how we handled it. This is how we did it. But they did not adopt rules as the CRB said they do. So 321 controls, my position is, and therefore notice was not given. And on those 2 positions, I believe that the commissioner's finding should be upheld. Thank you.
All right, thank you. Thank you very much for your arguments. We will take this matter under advisement. We look forward to seeing both of you at the appellate court in person in the future, and we will stand adjourned until 9 a.m. tomorrow morning.
Thank you, Your Honor.